following is a project of our nonprofit newsroom. Support Midcoast Morning and local community-centered journalism today by signing up to be a monthly sustaining donor at chly.ca/donate. It doesn't take much money to support local news.
Hello and welcome to Midcoast Morning. I'm Joe Pugh. Vancouver Island University is suing student protesters, seeking an injunction to bring an end to the Palestine Solidarity Encampment on its grounds. In a notice of civil claim filed with the BC Supreme Court this week, the university names 6 defendants, along with John Doe, Jane Doe, and all unknown persons operating as the Palestinian Solidarity Encampment. 5 of the 6 defendants named are listed as students of the university. The other is listed as a former student applicant. The claim says that the defendants have engaged in conduct that unreasonably and substantially interferes with the ability of the university and the public to use the campus or parts thereof. It lists what it describes as various disruptions and occupations of university buildings. In the claim, the university says it was forced to cease operations of the campus Starbucks location on May 8th as a result of what it describes as disturbing and threatening signs as well as chalk messages, which the university says were put up and written by the defendants or a number of them. The claim says the university has suffered and continues to suffer loss and damage as a result of what it describes as the defendants' ongoing nuisance and trespass on the campus, conspiracy to injure the university, and intentional interference with the university's contractual relations. In addition to injunctive relief, the university is seeking general and special damages and costs. The Palestine Solidarity Encampment has been up on campus near the library since May 1st. Last week, protesters had been ordered to vacate by Monday, July 15th. The notice of civil claim comes after they failed to do so. To better understand the legal stakes, I spoke with University of Windsor law professor Richard Moon.
My name is Richard Moon, and I am a professor of law at the University of Windsor.
And what stood out to you reading the notice of civil claim?
Well, I don't think anything in particular stood out to me in the sense that this is now becoming pretty familiar. It's become the response of most, but not all of the universities to the encampment question. So I guess the responses have, in some cases, been immediately calling in the police, who have some discretion to respond or not respond, and the almost immediate takedown of an encampment, which is what occurred at Calgary. Or sometimes the police have expressed some reservations about intervening in what at least appears to be a peaceful protest. And so the other route that many universities pursued is to seek an injunction through the courts. And I think that's not surprising that they pursue that route. And it's not surprising that the police have had some reservations about intervening because there is a real question about the right of students to engage in protest, in this form of protest in particular. And so a court order gives a kind of legal authority to the university and therefore also to the police to intervene and take down the encampment.
Could you explain just in simple terms what exactly an injunction is and how that works?
Yeah, these injunctions, of course, it's important to note, there are often 2 steps to any kind of process seeking an injunction. I'll say a bit more about what an injunction is in a second. Generally speaking, the initial step is very much a preliminary matter. Usually when an injunction is sought, there is a claim by the party, the university, seeking the injunction that there is a kind of urgency, that some injury or harm is happening to someone, in this case to the university community, and it's vital then that the courts intervene, grant this injunction, which effectively orders the shutting down of in this case, the encampment, or an injunction can be simply to cease and desist a particular kind of behavior that is claimed by the university, in this case, to be harmful. And then the second step, which often is never followed, is a full hearing on the question and whether or not a permanent injunction is properly granted. But in most cases, the issue is really decided at the first stage, because if it's ordered the encampment be taken down, generally speaking, those involved in the protest don't pursue the second stage and make the argument that the injunction shouldn't be made permanent or whatever.
So in this claim, VIU is seeking an injunction, and it's seeking an order allowing people agents of the university or whoever to kind of remove the physical structures of the encampment. They're also seeking general damages, special damages, and costs. Could you give me a sense of what that could mean?
Yeah, well, I mean, costs is pretty straightforward. Costs refers to the costs of pursuing a legal process. So that's what they mean by costs. And when costs are awarded, it usually isn't the full costs. It's usually a portion of what might be the reasonable costs of such an action. But the other claims really relate to what we in law refer to as torts. So civil wrongs distinct from criminal wrongs. So if the criminal process, I'm sure your listeners know, generally means that the police lay charges, there's a prosecution, there's a criminal trial, and all that goes with a criminal trial, the various processes that are tied to it. And generally speaking, if somebody is found guilty of committing a crime, there are sentences that follow from it, whether it be incarceration, probation, fine, or whatever. When we're talking about a civil process, like here, the argument the university is making is that we experienced a harm, a loss of some kind as a consequence of the actions of these protesters. And we are seeking compensation, monetary compensation, for the harm we experienced. So what have they claimed? Here they've said trespass. So there's been an interference with our property rights. That's a harm to us, for which we should be compensated. There's been a nuisance, private and public nuisance. So the distinction between those is not really easy to explain, and I won't try. But the idea of nuisance is really an interference with the ordinary life, the ordinary operation, in this case of the institution and the members of the university community. And so what they're claiming then is, as a consequence of the actions of the protesters, which amounted to a breach of certain torts, as we've described them, civil rights, we have experienced loss, and we are asking the court for compensation for that loss.
Maybe also worth noting, among there is listed as the torts in this civil claim is the intentional interference with contractual relations. There's a bit about what the university describes as disruption to a Starbucks. I'm wondering, what kind of order of magnitude could these costs potentially be? Or even before we could possibly get there, is there any kind of precedent for a situation like this? I know, for example, the University of Waterloo in Ontario brought a lawsuit against student protesters at an encampment, but that was dropped. Has something like this ever been taken to court?
Oh, I'm sure it has, but I'm not really in a good position to give you examples of it. Certainly in the context of these protests, the encampment protests within Canadian universities, sometimes in the statement of claims that have been made, there have been requests for monetary compensation. But as far as I can tell, those are generally dropped. The university's main object is simply to bring an end to the encampment. So as you say, the University of Waterloo, some extraordinary amount, I think $1.5 million or something, was claimed by the university, which really just came across as an intimidation tactic. And the university, I think, came under a lot of scrutiny and I suppose complaint around that, and decided not to pursue that. And again, here I'm imagining that the addition of civil claims here, beyond simply the order to bring an end to the encampment, really is to add to the pressure on the students to end the encampment. And the university isn't really imagining that they'll get monetary compensation. I don't know the financial situation of these students, but there's a pretty good chance they are what we sometimes describe as judgment proof, which is to say they just don't really have the resources to pay a judgment in any event.
There are 8 people sort of listed by name in this encampment, in this civil claim, and it's also listed like all unknown persons operating as VIU Palestinian Solidarity Encampment. What is maybe the sort of level of responsibility for people who have participated in the encampment in any way?
Well, again, if the principal remedy being sought here by the university is simply an order that the encampment be shut down within a particular time frame, if that's the principal remedy, then anybody who continues beyond, the issuing of the order and whatever deadline is set to participate in the encampment, then I guess can be found to be in contempt of court, which itself is a criminal offense. So I think that's the main lever, in order to try to bring an end to this and have people vacate the encampment. As you may know, the University of Toronto encampment, the participants there decided to just pack up themselves and leave without the police being called in to shut it down.
Now, the notice of civil claim dedicates some space to the encampment specifically, the structures. It also lists what it describes as disruptions to the campus Starbucks, for example, to a board meeting, to the university library. It lists what it describes as some occupations of offices and administration buildings. From like a legal standpoint, is there any kind of significant distinction between the encampment and maybe some of these specific incidents?
Yeah, there's a few things I could say about that. So, first of all, any kind of protest, and protest is protected, as a matter of free speech, whether that's under the university's freedom of expression policy, and I have no doubt the university has such a policy. Most universities do. Or whether or not the Charter of Rights is applicable here, and the Charter protects freedom of expression, and we could talk about that in a moment, whether the Charter might be applicable here. But in any event, inasmuch as protest, or expression more generally, is protected on campus in the public or open space of the campus, protest is invariably disruptive to some degree. And the difficult question, for which there is no easy or simple answer, is, well, how much disruption is too much? Or it's disruptive in a small way, but it's gone on for a long time, and that's too much simply as a matter of time passing. I would give the example of the convoy protest, Parliament Hill. If a group of protesters had arrived in Parliament Hill and had honked their horns loudly for an afternoon, that would be one thing. But the fact that they, entrenched themselves there, blocked traffic, honked their horns all the time, and really significantly interfered with the life of people living and working in downtown Ottawa, that was a different matter. That clearly went too far. So the first question has to do with the encampment itself. I haven't seen the encampment, at the university in Nanaimo. I have seen other encampments, the one at University of Toronto. I haven't actually seen the one at Windsor, but I'm aware of it. And, they were set up in such a way that they did not interfere in any real way with the operation of the institution. They were confined to a certain space. They didn't involve blocking access to buildings or obstructing, movement throughout campus and so forth. They did take up a certain space, and for the time that they were in place, there was not free movement of others through that space. So they were disruptive, but not in a significant way in terms of the ordinary life or operation of the university. So with the encampment, the question really just is, well, it's gone on for a long time. How long is too long? And it was not unreasonable after, a few months or whatever to say, yeah, this has been long enough. This property could be used for other purposes and so forth. So that's the one question. And then when it comes, though, to occupying buildings or obstructing access to buildings and so forth, that's a different matter. And that kind of obstruction of the operation of the institution, clearly will be viewed as going beyond the bounds of acceptable disruption in terms of a protest. Now, people engage in civil disobedience and they may feel fully justified in doing so. So I'm not making an argument that people shouldn't sometimes, when a situation feels very urgent to them, engage in civil disobedience, but that invariably involves accepting the potential legal consequences of your activity. So if people may decide they feel justified in obstructing access to a building or occupying it, that's one thing, but there seems no doubt that the institution will be legally supported in seeking an end to that kind of blockade or occupation of a building. So the hard question here, and all I know is what I'm reading in the application. I haven't witnessed, the encampment and the protests, and I don't know what the response is, in fact, from, if there is one, from the students involved in the encampment. The question for me would be, are these other protests extensions of the encampment? Are we talking about the very same people who are leaving the encampment, going out, interfering with access to a particular building or occupying that building? Or could it be that these are distinct actions engaged in maybe by some of the same people or by other people who are not in the encampment? And it strikes me that's an important difference, because you can't necessarily blame those in the encampment for the actions of others who may be inspired by the encampment but aren't actually the same people. So I look at the decision of the court in Ontario to grant the injunction shutting down the University of Toronto encampment. And one of the things that's really important that the judge does, even though the judge did grant the order, the judge says at the beginning of his judgment that there is no evidence that anti-Semitic speech or hate speech was coming from the encampment, or that there were any acts of violence or threats engaged in by the occupants of the encampment. It's true that there were, elsewhere on the university campus, acts that may well have amounted to, anti-Semitism or intimidation and so forth. But the occupants of the encampment were not responsible for those and should not be held to account for those. So that's really my question here is, are we talking about the same people? Is this just the encampment on the move doing different things? Or is it possible these are other people who are engaging in sympathetic actions? And if so, those in the encampment shouldn't be held to account for that.
Midcoast Morning is made possible by the Community Radio Fund of Canada's Radio Meters program and listeners like you. Support Midcoast Morning and CHLY's nonprofit newsroom today by becoming a sustaining donor at chly.ca/donate. Local news can't survive without your support. Another way to help us out is to share this show with your friends and tell them why they should support us. Finally, if you're listening to the podcast edition of Midcoast Morning, go and give us a positive review on Apple Podcasts or whatever podcast feed you use. It helps people find us.
Today on the program, we're exploring the Notice of Civil Claim filed by Vancouver Island University against persons operating as the Palestine Solidarity Encampment. The encampment went up on May 1st. On Thursday, July 11th, the university ordered protesters to leave by Monday, July 15th at 8 a.m. After protesters failed to do so, the university filed a notice of civil claim with the BC Supreme Court seeking injunctive relief as well as general and special damages from the protesters. I'm speaking about that notice of civil claim with Richard Moon, a law professor at the University of Windsor. How long does something like this typically take to resolve or to reach the next step?
The injunction itself?
Yes.
The court. I mean, usually these processes are expedited. As you know, the court process can be a very long, drawn-out one. But when someone is seeking, or an institution like the university is seeking an injunction, their claim is there is an urgency to this situation. There is an ongoing harm that we are experiencing, and we are claiming that it needs to be shut down now to prevent the continuation of that harm. So usually the process is pretty quick, within 1 or 2 weeks. And how long the judge may take to make his or her decision, to issue a judgment, again, I don't know, but usually they try to turn it around fairly quickly. In Toronto, it was a longer process than one might have thought. The judge gave all the parties involved several weeks to prepare their case, and the judge took, I think, at least 10 days to issue his judgment. But I would anticipate this process will move fairly quickly, and a judgment will follow fairly quickly, one way or the other.
You've talked a little bit about this sort of inherent tension between the idea of allowing peaceful protest and the fact that a protest is sort of inherently disruptive. Are there any questions that maybe encampments across the country that you feel like they've raised from a legal perspective that we don't necessarily have the answers to?
Yeah. I mean, we've experienced these sorts of things before. The Occupy movement, for example, in many locations involved encampments. And ultimately, most cities obtained injunctions or court orders shutting them down. But they, for the most part, went on for a considerable period of time. And so by the time the various cities requested an injunction, it was pretty much accepted by the courts that this disruption had gone on for long enough, and there was no serious issue concerning the issuance of the injunction. Whether that's right or not, I won't I won't get into. But nevertheless, but the other really interesting and difficult issue that this has brought to the fore is the question of whether or not universities, at least when they're regulating speech on campus, are in fact subject to the Charter of Rights and Freedoms. So let me just give a little bit of background to that. So the rights in the Charter protect, of course, the individual's right to freedom of expression, for example, the right to assembly, the right to practice one's religion, and so forth. But it is understood, and our courts have made clear, that only state actors or only state action is subject to the Charter. So if somebody throws me off their property, engages in discrimination against me by removing me from their property, I don't have a Charter claim. I may have a Human Rights Code complaint against them, but I don't have a constitutional claim. It's only if it's a state actor or state action that I claim interferes with my right, my freedom of expression, for example, do I have a Charter claim? Okay, so in their early decisions, our courts, the Supreme Court of Canada in particular, held that universities are not government actors, so they are not subject, at least ordinarily, to the Charter. The early cases were about university mandatory retirement policies. And again, as I say, the courts found that this did not amount to age discrimination under the Charter because the Charter was not applicable. There might have been Human Rights Code complaints and so forth, but not a Charter, a constitutional complaint. Okay. However, the courts in Alberta have made, let me step back. The Supreme Court of Canada said, but there is another way in which the Charter might be applicable. Even if it is decided that a particular entity, like a university or a hospital, is not itself a government actor, is not simply an extension of the state, sometimes an otherwise non-governmental actor may be carrying out government policy. Imagine a private prison, for example. So, they're carrying out government program or policy. Of course, they should be subject to the Charter. So the courts of Alberta said, when the university is regulating speech on campus, we believe they're engaging in government-like action and should be subject to the Charter. Now, courts in Ontario and British Columbia reached different conclusions on this question. The state of things in British Columbia at the moment, I am not sure. The existing precedent would be that the charter does not apply to university regulation of speech on campus. In Ontario, there's a pretty good argument that things may have changed because the Ontario government has done two things. First, the Ontario government has required all universities to put in place free speech policies, to draft and establish free speech policies according to certain specifications. And they have also required all universities to put in place rules protecting individuals from hate speech, discriminatory speech, and so forth. So there's an argument that can be made that at least in Ontario, as in Alberta, universities, when regulating speech on campus, are carrying out government policy. And so that's one of the claims that have been made here. I don't know how strong that argument would be in British Columbia, but it is a live argument that the charter may be applicable. And if that's the case, then the students engaging in encampment have a protected right under freedom of expression, Section 2B of the Charter, and a right to engage in peaceful assembly. Now, again, the rights in the Charter are all subject to reasonable limits. So that's the whole question about I may have a right to protest on campus, but it can be made subject to reasonable limits. In other words, if they're too disruptive or the disruption goes on for too long, the university may well be justified in shutting that down or preventing that kind of protest.
Which would all be up to the discretion of a particular judge.
Well, in this case, when they're seeking an injunction, that would clarify for the university whether the limits had been exceeded, and the judge would make the determination that, yes, this is a reasonable limit now on the exercise of these particular rights.
What about the intersection maybe between what you're talking about there with freedom of expression and something like the BC Trespass Act? That's the thing. I mean, trespass, in all of these cases, the university said, well, it's our property, it's our private property, and therefore we get to control or regulate what goes on. But it's not so simple as that. It's not like, my backyard or my apartment or whatever it might be, where, it's my property and I have some right to control and I can exclude people who I don't want to be physically present. The university is much more of a public-like space. And so trespass law can't simply apply. Certainly if we say the charter is applicable, trespass law can't simply apply in some straightforward way as if this were private property. If we say that the university, when regulating speech on campus, is a government actor, then it has obligations to protect and respect speech and protest on campus, and trespass law can't simply apply in some automatic fashion. Is there anything else you feel like it's important for people just on the ground in Nanaimo to know about this situation, or, how the legal proceedings might play out?
Nothing that I can think of off the top of my head. I mean, I would just stress, I think, the important points that a university is not just a private actor. Whether or not the charter applies, the university still is a public-like entity. And the starting point is that students and others in the university community do have a right to engage in speech, expression, and protest on campus. And again, that protest is always to some extent disruptive, and the difficult question remains, how much disruption is too much? Now, the allegation here is that this wasn't just an encampment, but other forms of more highly disruptive behaviors occurred here. So that makes it a little different, I think, from many of the other encampment situations. And again, the other thing is there have been a lot of hearsay, rumor, claims of all kinds of terrible anti-Semitic speech emanating from these encampments. And for the most part, that's proved not to be so. Again, I have some, knowledge of the University of Toronto encampment, and I think the judge, quite rightly, was very carefully organized, and they really sought to control the message and keep anybody out who might engage in bigoted, racist speech that was contrary to their message. And the judge, I think, quite rightly said no evidence whatsoever of anti-Semitic speech coming from the encampment. So I think it's important for people to know that, even if the ultimate decision is this has gone on for a long time, or this has been too disruptive and should be shut down.
Maybe before I let you go, I'm wondering if you could interpret some of what you see in the notice of civil claim as separate from the encampment, some of the occupations, some of the disruptions that it's listed. If what the university is alleging is true in those cases, is that kind of a more open and shut case than...
Well, potentially. I mean, again, the problem is, first of all, if they want to independently claim damages or harm were suffered as a consequence of this occupation of this building or this obstruction of entry to this building or on-campus business like Starbucks, if they want to claim that and seek damages, they're going to have to show that the individuals who've been brought into this action are the very same individuals who participated in those obstructive. And maybe they can. I have no idea what the circumstance and what the evidence will be. So that's one thing that would be an issue to my mind. And again, as I mentioned earlier, the other question is, are these the same people? And should the encampment and those who are engaged in the encampment protest be held accountable for these other actions? It may be it's the same people, but it might be that it's not. And the university, I think, if it's going to use that to add to its case to shut down the encampment, would have to show that these two things are linked.
Richard Moon, thank you so much for taking the time to speak with me about
this.
No,
my pleasure. Thanks for inviting me.
Richard Moon is a law professor at the University of Windsor. CHLY reached out to VIU and were told via email that no one was available for an interview on the subject. We also reached out to the lead defendant listed, but did not hear back ahead of recording time. A representative from the Vancouver Island University Students' Union said via email that the union is aware of the situation, but is not able to provide further comment at this time. That's our show for the day. Thank you for joining me. I'm Joe Pugh, host and producer of Midcoast Morning. Jesse Woodward is our executive producer, and Arby Frew is our technical advisor. You can sign up for CHLY's newsletter at chly.ca/subscribe for updates from our nonprofit newsroom. Our theme song is First One by local Nanaimo band Waste Management. If you have a story you'd like us to cover, email us at news@chly.ca. If you have a story you'd like us to cover, email us at news@chly.ca. That's all for now. I'll talk to you on another Midcoast Morning.
Midcoast Morning would not be possible without the funding of the Community Radio Fund of Canada's Radio Meters program and listeners like you. Midcoast Morning is a project of CHLY's nonprofit newsroom. Support nonprofit journalism in Nanaimo and on the Salish Sea today by becoming a monthly sustaining donor at $5 or more per month. Support the program at chly.ca/donate. If you're already a supporter, record a voice memo telling others where you're listening from and why they too should support our work. After you're done, you can email it to us. Also, share the podcast with your friends. While Meta is blocking Canadian users from sharing news content on their Facebook feeds, you can still share our podcast directly with your friends via Facebook or Instagram Messenger. Finally, this program acknowledges and gives thanks to the Snuneymuxw First Nation as we broadcast and podcast from their traditional territory. Thanks for listening.